Welcome, everyone. Good morning. And today we have our first session, and we're going to have 1 hour, and we have two valuable panelists with us. We're going to talk about the conceptual framework and the protection of minorities. And I'm not a speaker here, but I am closely monitoring these issues and taking this opportunity. I would like to comment on the remarks of esteemed rapporteur, and I took immense pleasure at listening to him as a person who monitors this area. Legal people and law practitioners have a particular approach. Maybe it's a professional deformation, or maybe it's vulnerability, and everything under the sun can be described and defined by law. This is the argument that we support all the time. Yes, even the sun itself, well, for example, there is a United Nations instrument, and the sun can be described there. However, life cannot be established on the basis of such legal concepts, and it is basically a fallacy to be able to frame everything with law and legal descriptions of these concepts and the inability to describe these concepts. And in terms of non-legal aspects, the description of minorities should be discovered in all its spheres and dimensions, and such a perspective should be developed and formulated. And esteemed Special Rapporteur has mentioned all the human rights ideals and in the world after the 1945, and since then, great progress has been attained, and there is now human rights standards, and there is a human rights framework, so we shouldn't be really undermining the function of the legal systems around it, but a specific framework and mechanism for minorities, and an agreement in this respect does not exist, as the Special Rapporteur has also expressed. And panelists will be making reference to that, but in some human rights agreements, some provisions are made specific to the minorities, and Turkey has an unchangeable practice, which is basically putting a reservation on that. And when it comes to the definition, when it comes to the description, it's quite a tricky matter. And extra legal dimensions of this description and a cumulative perspective to establish reality would be something that we will be discussing in this particular panel. If you have questions, we have a Q&A session for 15 minutes at the end of the speeches. I would like to start by introducing the first panelist, Olgun Akbulut. He is from Kadir Has University. For over 30 years, he was a student of mine at Istanbul University, and now we're colleagues, and I'm proud to be sharing the stage with him. And briefly introducing him, he has taken part in various programs in human rights. For example, he was in Lund. He also had his PhD studies at Harvard, and in constitutional law and human rights law are the areas that he works on, and he has had certain publications. The legal grounds of living together in peace, for example, was his PhD thesis, constitutional and religious diversity from theory to practice in minorities, a publication dating back to 2019, and the historical evolution of minority rights is also one of his publications. Now you have the floor, esteemed Olgun. May I start with 20 minutes? Thank you very much.
Thank you very much for this kind introduction. I already sent my text to you, so let me also open that up and share that with you. So in 20 minutes maximum, I wanted to present you with some highlights. Obviously, we have some time limitations, I started with the period that followed the First World War, and I have a definition from there. And then after the Second World War, obviously there are other legal definitions, certain concepts that were conceived, and I'd like to also tell you about those and certain dimensions of these concepts, so on and so forth. This is what I'm going to try and tell you about. Now, in 1930, what preceded the League of Nations, the International Permanent Court of Justice, has, well, actually, to protect minorities, it interpreted certain concepts, and one of these concepts, in one of the jurisprudences, one of the definitions is as follows: the existence of a group or a person in a country, in a region, having their own race, religion, language, and traditions, protecting these and continuing to observe their religion to make sure that their children are trained and educated according to the traditions of their culture, to offer solidarity within concepts of race, religion, language, and tradition. This is the definition of the minority that they came up with 100 years ago, and today we have a difficult time sort of doing that. And going back to 1974, Francisco Capatorti, who was a special rapporteur of the UN on minorities, proposes the following definition: a group numerically inferior to the rest of the population of a state, in a non-dominant position, whose members, being nationals of the state, possess ethnic, religious, or linguistic characteristics differing from those of the population, and show, if only implicitly, a sense of solidarity directed towards preserving their culture, traditions, religion, or language. So compared to the previous one, actually, race is no longer in use in this definition, as you see, and I will get to that shortly. Another special rapporteur, Yul Deschen, also came up with a definition and also talks about a group of citizens of a state constituting a numerical minority and a non-dominant position in the state. Again, that is emphasized, and we will get to what that means. To continue the definition, endowed with ethnic, religious, and linguistic characteristics, ethnic, religious, linguistic characteristics, and Mr. Special Rapporteur also talked about the concept national, but we will delve into all of these concepts, really, what ethnic means, religious means, linguistic means, and why the word, the concept racial was abandoned. So, to continue with the definition, these characteristics, which differ from those of the majority of the population, having a sense of solidarity with one another, motivated, if only implicitly, by a collective will to survive, and whose aim is to achieve equality with the majority, in fact, and in law. And minority rights, actually, it was defined by Aston Ade in 1993. It's a very brief definition. It says a minority is a group of persons resident. Again, the concept of residency, it no longer talks about citizenship. It talks about residency, resident within a sovereign state, which constitutes less than half of the population of the national society, and whose members share common characteristics of ethnic, religious, or linguistic nature that distinguish them from the rest of the population. Again, this has changed considerably, this definition. In 1997, minority denotes a group of persons in principle permanently resident. In the previous definition, it was residency, and now it's permanently resident. Numerically fewer, it's always there, than the remaining population of that state, and in other words, constituting less than half of its population, endowed with national, ethnic, religious, and linguistic and other related characteristics, like culture, traditions, and so forth, distinct from similar characteristics of the rest of the population, and displaying a will to preserve the existence, identity of the group. This shall not be interpreted as authorizing or encouraging any action aiming at depriving anyone of the status of citizen or permanent resident. So, you don't need to be a citizen. Yes, you need to be a resident. And now it talks about permanent residency, but permanent residency should not preclude or citizenship should not preclude someone from being a minority. And in 2020, Fernand de Varennes, his definition is an ethnic, religious, or linguistic minority in any group of persons that constitutes less than half of the population in the entire territory of a state, whose members share a common characteristics of culture, religion, or language, or a combination of any of these. So I think in Canada, for instance, this was problematic vis-a-vis Quebec. Again, we see the concepts of culture, religion, or language, or a combination of any of these. I will get to that later. A person can freely belong to an ethnic, religious, or linguistic minority without any requirement of citizenship, residence, official recognition, or any of these, any other status. Again, this is outlined in this definition. And when we go back to 1966, the Convention, Article 27, we see, again, in those states in which ethnic, religious, or linguistic minorities exist, persons belonging to such minorities shall not be denied the right in community with the other members of the group to enjoy their own culture, to profess and practice their own religion, or to use their own language. In 1994, there's an interpretation, number 23, Article 27, and here again, one thing that citizenship is underscored. It says here that states should not see this as rights that only citizens can enjoy. Those rights are limited to political rights. And again, it is underscored here that these people do not have to be citizens to be considered as minorities. So let's get to what we're going to talk about today. Racial, ethnic, religious, and linguistic. I mean, racial is no longer applicable, but the United Nations Genocide Convention and United Nations Prevention of Racial Discrimination Convention makes mention of these. Race, ethnic and cultural minority. This is quite widely used today. Racial, the concept of race was discriminatory because you cannot choose to be a racial minority. You get this identity when you're born, and you need to take it to your grave, basically. So President Obama was of African origin, and is he a racial minority in the U.S.? Yes, but President Obama, why does he have to be protected compared to the Caucasian Americans? Does he have any characteristics? No. He was born in the U.S. culture. He speaks English. That's his native tongue, and he is sort of not any different than an Irish American, right? And is President Obama a racial minority? A racial minority doesn't really make sense. And similarly, ethnic minority, again, that has turned into culture, evolved into culture, because people may come from different ethnicities, but they share the language of the majority, or share the faith of the majority, and you may come from different ethnicities, speak the same language, have the same culture, have the same faith. So ethnic origins is also sort of defunct. We need to talk about cultural differences. Yes, ethnic differences may yield cultural differences, but that is not always the case, and not necessarily the case, and there might be other reasons behind this as well. But that is why, where we are today, we talk about cultural, religious, and linguistic minorities. These are the three main categories. As for religious minorities, here's the debate. And the difference between sect and religion. If you're a part of a different sect, does that mean you're a minority? And I cannot give that an answer. Are atheists, for instance, a minority? Would they fall into that category of minorities? That's another contentious issues, or philosophical persuasions, for instance. When we talk about linguistic differences, again, mother tongue comes into the picture. if you have a different mother tongue than the dominant language in the society, that might be a consideration. Is your mother tongue what you learn from your mother? And that's not always the case. It's the language that you're born into, right? And one person might have more than one mother tongue. Different dialects, I mean, does that mean a different linguistic category? Or if you use the sign language, for instance, are you a linguistic minority? And my answer is, in many countries, the sign language users are actually seen as minorities, linguistic minorities. So let's also talk about national minorities. And, we also talk about that quite often, because when we obviously the Lausanne Treaty, when we talk about minorities, we immediately talk about the Lausanne Treaty, and also because we're part of Council of Europe, we're part of this debate. National minorities are actually people who have a kin state outside the state that people live in. And if you have that status, for instance, if you are a Slovenian living in Hungary, or Germans living in Poland, or Polish living in Germany. This has to do with the history of Europe. In the Middle Ages, religious states were dominant, and there were religious minorities only. When nation states triumphed in the end, obviously borders changed and nation states were built, and national minorities emerged as a concept. So this is very much entrenched in European history. But you can also question who are the people who do not have linguistic or cultural differences. And I think the UN definition makes more sense. But anyway, there's also this concept of national minorities. So there needs to be kin states. That's number one. But as far as I can tell, when we look at European countries, and when we look at who they recognize as minorities, we do not really see kin states only. For instance, in Spain, in the Basque country, the Spanish state sees them as a national minority, not because there's a kin state of the Basque people, but there's something else within this concept, I tend to think. And numerically, if the population is wide enough, and if they have a national identity, if they have a strong national identity as a group, then states also recognize them as national minorities, and sort of limit that category, because the Basque people, they want a Basque country, so minority rights given to the Basque people partially are national, but also as part of the Spanish constitution, they have this autonomy, and that's the maximum they could get in that state, and they do not have the right to self determination. So it is, it makes sense from that point of view. They delineate this group. And the other one, in certain European states, we also see that if groups that serve the national culture for a long time, they're also seen as a national minority. Like the Romani people in certain countries are recognized as such, not because of the fact that they have a kin state. In many European as well, the Jewish minority is seen as such a minority, not because of Israel, but because of the fact that they have been living in these cities, in these countries for a very long time, and that because of the fact that they have been contributing to the national culture. Now let's go down. These were subjective components, but there are other components at play, such as subjective components, definition of one's own identity, and if a person, the person needs to see themselves as a minority for you to be able to implement minorities policies to them. I mean, sometimes people say that no one should be forced to, own the identity of a minority. Yes, obviously, if the person doesn't want to see them as such, obviously that's fine. But one thing that we need to look at is, despite the fact that they have these objective features, if they don't want to be a minority, is there a reason behind that? Based on objective criteria, I mean, if the person feels disadvantaged, then they might opt out. But if you guarantee to them that it won't be a problem if they still want to opt out, then yes, obviously they might wish not to define themselves as minorities. For instance, we were visiting Germany and we went into a McDonald's, and there was this young person helping us, a worker, and the name was Turkish name tag, and they wanted, our group wanted to speak in Turkish with him, and he said, I don't speak Turkish. Yes, maybe he was born into a Turkish family, but most probably, I mean, he was voluntarily assimilated. He's of Turkic origin, perhaps, but he's German and he doesn't speak Turkish. So how can you label that person as a Turkish minority in Germany because he's not interested? Simple as that. And there might be some people in Turkey who are not interested. So I mean, what we're talking about here is those who are interested, who want to preserve their identity, their linguistic features, and pass it on to their children, and who want to continue to live as who they are. Or otherwise, you cannot force people to become or to be categorized as minorities. Last 5 minutes now. Obviously, this is the list. Now, obviously, we will not be able to exhaust this list. So let me focus on a couple of things. A dominant, not non-dominant, for instance, it was abandoned later on. But being dominant is actually being in government. Politically, being dominant is what is meant here. But actually, you may be dominant, but you, I mean. If you have the features outlined, are you no longer a minority? The apartheid regime, the white minority, for instance, they were dominant during apartheid, and during their government, they were not minorities. Some people say, and I tend to say that, tend to think that. I mean, even during apartheid, they were minorities by definition. Did they need minority rights? That's another debate. Probably they didn't, but I mean, if you are numerically lower and if you have the political dominance, then actually that is a testament to the fact that there is no democracy in that country. And in apartheid South Africa, that was the case. There was no franchise, universal franchise, and the Assad regime, quote unquote, religious minorities in power, right? And in certain other countries, you might also see this. In the absence of democracy, a minority might be in power. This is a democracy problem. So just because they're in power, I don't think they're not minorities, despite the fact that they may not need minority rights. And a culture of solidarity, albeit implicit, this is also abandoned. I mean, why should people have to exhibit solidarity with one another to benefit from rights? I mean, a member of minority group X brings their child to school, family Y, family Z also bring their kids. I mean, that doesn't mean that there's solidarity between them just because they send their kids to a minority school. Why should we be engaged in solidarity? Obviously, solidarity is good, but it should not be a prerequisite, right? Like you shouldn't be expected to demonstrate it, right? So I think that's also redundant. Yet another topic, residency versus citizenship. Obviously, this is a lengthy debate, but let me conclude with that. If you pre-require citizenship, then minorities may not be accepted as citizens. In one of the conventions of Council of Europe, it says 10 years of residency. I mean, once you complete that, the path to citizenship should be opened. But states, many countries around the world, sort of extend that. I mean, will you wait to become a citizen? Before becoming a citizen, you should also be able to enjoy these rights. And secondly, residency, permanent residency or residency. Now, the UN interpretation says those visiting a country, even they can be minorities, and this brought about the debate whether tourists would be minorities. That's why they had to take a step back and underscore the concept permanent residency. So permanent residency and permanent working permit. I mean, there needs to be some permanence in that relationship. It is indicated. So, from a liberal point of view, jurors and theoreticians accept this explanation. But I tend to think that not every permanent resident is necessarily someone who needs to benefit from minority rights. And I knew two siblings when I was living in Sweden. They were both Turkish. They're both Swedish citizens. Let's push that aside. But one of them um, was looking to purchase property in Istanbul, and they wanted to come and start a new life in Istanbul. So, I mean, um, the whole thing is up for debate. I mean, individuals' needs need to be also taken into account. If states are good natured, they should recognize their minorities. It's not so difficult. OSCE, the first, the Van der Stoel, the first rapporteur, actually says something wonderful. You know a minority when you see one. We probably all know a minority when we see one, and legally, to define them shouldn't be so difficult. Thank you. Olgun Akbulut, thank you very much. Now, just a bit of information. I think it was 13 years ago, back in 2010, TÜSİAD brought together a group of jurors and invited them to come up with certain principles for a new constitution. And I was one of those experts, and we looked at constitutional law, international law, public law, and it was a council of 6 people, and Professor Ergun Özbudun and myself, we were co-coordinators of that working group, and we published a book at the end of that process. And we looked at the Lausanne Peace Treaty and what it says about protection of minorities, and we looked at the legal regime that, I mean, Articles 37 to 45. We said that they need to be sort of brought into the constitution, recognized by the constitution. So in that report, you will find that. And I don't think this is debated enough in constitutional debates in Turkey. So this was a bit of a first. And I don't know, obviously, if TÜSİAD it can be the pioneer of a new drafting process for a new constitution. But that's the Turkish Association of Business People. I mean, when we look at the Lausanne Peace Treaty, obviously, I think we need to recognize that it's a peace treaty and it creates an objective status, and we cannot overlook that characteristic of the treaty. And it's not a treaty that you can withdraw from or that you can annul. That would be highly problematic, and not just legal but political problems as well. There might be some grave consequences. That is why, and also this treaty needs to be implemented effectively domestically, and for that you need a propeller. You need a certain legal propeller, and you could do that with some sort of constitutional support. That was our suggestion, but obviously, like I said at the beginning of this session, you cannot solve everything through legal means. Obviously, that would not be possible. I'm not saying that we need to yield to illegal means, but obviously, there's only so much you can achieve with law. So yes, constitutional recognition is important. But we are living at a time when the constitution is also breached. Sadly, that is very much the case in our country right now. Now, let us continue with our second speaker. But before that, let me introduce them very briefly. Yeşim Bayar is her name, and she's going to talk about international actors, minority regimes, and restructuring after the Ottoman Empire. And she teaches at St. Lawrence University at the Department of Sociology. She studied at Middle Eastern Technical University, and also she continued her studies at London School of Economics and McGill University Sociology Department. And she focuses on the relations between states and minorities and nationalism as well. And she has also published extensively in many different academic publications throughout the years. So please, over to you. You have 20 minutes. Thank you very much. Yes, hello everyone. Good morning. First of all, allow me to thank Hrant Dink Foundation for bringing us together at this significant event. We're here for the next 2 days, and I'd like to thank them for their hospitality. I feel so grateful to be here. And I'm going to go back compared to what Olgun Bey said, and also go back from where Monsieur Dover talked about. I'm going to talk about the League of Nations, and actually, I shared a draft. I mean, it's a new initiative for me. It's a big project, but I wanted to give you a small portion of that project. And by no means is this final. So, apologies if anything is amiss. And with your permission, I should like to continue in English. So. But please bear with me, and also if I take too much of your time, please issue a warning.
The First World War, the aftermath of the First World War, and I'd like to discuss the interactions of the minorities themselves and the League of Nations during this time a little bit, and the role of the workings of the League of Nations on the national states, like particularly the Turkish case. But I'm going to start with a more personal story, if I can get this to work. Go on to the next page. Geldi. Evet. Okay, this is it. So this is Madame Nektar Duz, as her name appears in the League documents. She was born in Istanbul in 1864, and she first appears in the League of Nations system in May 1933, when she sends her first petition to the League. This first petition will be followed by a series of other petitions in the following year, and the correspondence between herself and the League will continue up until the latter half of the 1930s. But at the time that she's first writing this first petition, she had been living in Paris for more than a decade. And she also seems to have traveled during this time back and forth to Turkey multiple times. In the petitions, she seeks restitution for her properties that she had in Istanbul and Izmir, and which were confiscated by the Turkish state at the time. And we learned that her sister, Madame Mısırlıyan, and Nektar Duz inherited from their father an apartment in Pera, 2 shops in the same area, 1 house in Parmakkapı Sokak, which I believe is in Beyoğlu, a yalı in Yeniköy, and some land in Izmir. And she mentions that while her sister, who had become at one point an Italian national, was able to receive some material compensation for these properties, Nektar Hanım did not. So she's seeking a total of 400,000 Swiss francs from the Turkish government, or she says a cancellation of the seizure over the properties. And in her petitions, she also informs the League that she first sought redress in Turkey from the state. And she had court cases that were looked at, and the Turkish state basically eventually decided to dismiss her case, saying that the law of abandoned properties applied to her case. And her appeal to the League comprises a long list of documents. It's well put together, argued in detail, and where she makes a case. She makes cases for the fact that she was not a fugitive firari. She always remained a Turkish national. She actually held a valid passport, who was constantly renewed by the Turkish consulate in Paris, and she did not abandon her properties in Turkey either. She had a manager who was running these properties or managing them. She also makes a strong case as to how the Turkish state's actions violated multiple articles of the Lausanne Treaty, including Articles 39, 40, and 44. And as an Armenian minority and Turkish national, she appeals to the League for help. The League bureaucrats forward these petitions to the Turkish government and ask for their observations. And every time you get a pretty generic-looking reply from the Foreign Ministry's office saying that her case didn't require any attention on their part because it, again, the legislation in Turkey sort of doesn't see her case as a problem. In November 1934 or thereabouts, the League bureaucrats decided to be a go-between, to informally sort of bring together government officials and Nektar Duz to find what they call an equitable solution to the problem. We also learn from the League documents that conversation didn't go anywhere and didn't produce any desired outcomes. And the League eventually closes her case and decides not to forward it to the League Council, which would have been the higher up sort of organ at the League. Now, her story is not unique, unfortunately. This is, of course, a very personal story, but it is also very much the story of a bigger picture of structural, institutional changes around that time. And it tells us, at least gives us a lot of clues as to the workings of the League of Nations at the time, its obvious impacts on individuals' lives, but also the League's role in sort of shaping minority rights regimes inside the national boundaries. And if we step back a little bit and go back to the Paris Peace Conference in 1919, the discussions around the protection of minorities very much involved the notion of inclusion of minorities inside national landscapes. The international actors at the time believed that inclusion would lead in the long run to assimilation, hopefully. They hoped for that. And they said, which in turn would lead to domestic stability and peace. And domestic stability via inclusion will lead to international peace and stability. This type of sort of liberal look at minority protection regimes was also accompanied by a particular understanding of nationalism at the time, which looked at nationalism in a bifurcated way, right? So very much like some of the scholars at the time, actually. So they described good nationalisms of the West as being friendly, as a source of social cohesion, right? Bringing the community of citizens, acting as a form of social glue amongst them. Then they said there's the nationalism of the East, which was of a reactionary sort. It was aggressive and destabilizing. And this type of nationalism was what needed to be reined in. And the minority right regimes, as it was formulated in the 1920s and 30s, was seen particularly important for those nations like the Turks, for example, so that, you know, again, nationalism shouldn't be a destabilizing force. So closely connected to this bifurcated way of thinking about nationalism was also the argument that not all countries had a minority issue. Henri de Jouvenel, at the time, who served as a High Commissioner of Syria and Lebanon, was quoted to have said that France, for example, did not sign any minorities treaties after the war because she had no minorities. To have minorities in France, they would have to be created in imagination, he remarked. So this frame of thinking and legitimation, as we know, was further embedded in a civilizational narrative, right, where there was this notion of a hierarchy of nations provided, a hierarchy of nations that existed, which in turn provided the justification for the mandate system, which was also overseen by the League at the time. So the ideological framework around this time that colored international actors and institutions such as the League's thinking was a great mixture of a particular sort of nationalism and liberalism, accompanied with a civilizational narrative. Imperialist type of thinking also continued. And above all, of course, there was this sort of notion that there's the sanctity of national sovereignty as well. And it is an extremely mixed bag, right, which involves loads of tensions within itself. And this mixed sort of ideological framework very much colored League's workings. And it also existed side by side by the nation states at the time that are being built or recreated, whose vision of nationhood, such as the Turkish one, for example, revolved around achieving homogeneity, right, and which was also increasingly and directly impacting the lives of ethnic and religious minorities inside the national territories. So what I am seeing when I look at the workings of the League and how they approach the petitions of the minorities themselves is working with this mixed ideological bag and against the sort of the demands of the national regimes. It is a picture where the League contributing eventually to the national state's pursuit of homogeneity, really, as opposed to finding resolution on behalf of the minorities themselves. So the League was tasked, as we know, with maintaining international peace, as well as the protection of minorities inside these signatory nations. When you look at the workings of the bureaucracy of the League itself, what you see is it's a handful of bureaucrats who made the final decisions that oversaw the petitions, like Madame Douze's petitions. And ultimately, the system worked in such a way that it sheltered treaty-bound states while providing a limited modicum of voice to the individuals or groups that are demanding restitution, like Madame Douze. The director of the minority section at the League, Pablo de Azcarate, I have a picture of him here somewhere. I don't know if I can get to it. Maybe I can't see. Ooh, okay. Like this? Oh, there he is. Okay. So he served as the director of the minority section in the 1920s up until 1933, I believe, or 34. And in his memoirs, he writes that the Minorities Treaty's aim was not humanitarian, was purely political. The object of the protection of minorities, he observed, was to avoid the many interstate frictions and conflicts which had occurred in the past as a result of the frequent ill treatment or oppression of national minorities. For the League, what was paramount were those minorities who would be at risk in initiating such interstate conflict. Otherwise, he wrote, the ending or lessening the oppression of minorities was considered a humanitarian activity which was beyond the League's mandate. Neither was the League tasked, he noted, as a dispenser of justice, even though petitioners like Nektar Duz thought the opposite, right? I mean, for the minorities themselves, this is what the League should have been there for. Otherwise, what was it doing? So tasked with a political purpose, as Askarate wrote, the minority section bureaucrats were very careful in refraining from actions and decisions that would be considered interference with national sovereignty. And as some League bureaucrats also mentioned in their memoirs, such a preoccupation often hampered their primary aim, which was to oversee that the minority treaties were adhered to. And crucially, the newly built Turkish Republic at the time appeared to be of little concern to them. As Askarate explained in his memoir, after the Greek-Turkish population exchange, the minority problem ceased to exist. Those are his words, to a large degree. And he writes, the questions placed before the League of Nations by both minorities, that is Armenians and Istanbul Rums, nearly always concerned protests against economic or fiscal measures adopted by the Turkish government as a result of the great task of internal renovation and reconstruction in which it was engaged during the period following the last war. These protests did not represent the minority as the victim of political persecution as such. And he so concludes that there were absolutely no question of importance that was raised during the whole of the last post-war period. And he certainly, while he's saying these things, of course, we know, right, I mean, how the Turkish Republic at the time was formulating policies and practices that targeted ethnic and religious minorities. So he's certainly minimizing the problems that existed even during his directorship inside Turkey. An examination of the League documents reveals that there are a series of decisions and actions taken both pre-Lausanne and post-Lausanne period by the League Secretariat, where minority requests were sometimes ignored and sometimes directly conceded in a fashion to the demands of the Turkish government. And there were also instances where the League's decisions or actions replicated the Turkish state's way of approaching and thinking about minorities. In all these different ways, the League helped to reproduce a minority regime in Turkey, which was very much shaped by the nationalist leaders of the new republic. On the whole, the League's actions and decisions were guided by a moderate, let's not rock the boat kind of an approach, which played into the hands of the Turkish state and made their life a little bit easier as they formulated anti-minority policies and legislation inside their territories. The Turkish state, on their part, used the rhetoric of the League itself to reassure them that everything was fine in Turkey. You know, we got all the legislation, don't worry about it. There's no discrimination and prejudice, absolutely non-existent in Turkey. And in the meantime, the League bureaucrats were, of course, receiving petitions, particularly from Armenians in the diaspora, but also from inside Turkey as well. For example, in July 1937, a letter to the General Secretariat was signed by Said Ziya, outlining in detail the state policies that targeted Kurds living in the Dersim region. The League bureaucrats decided, after receiving that petition, that no action was needed. A few months later, in November, another letter reached the League, this time signed by a number of Kurdish tribal leaders. This letter similarly, petition I should say, outlined the continuing harassment, bombardment, forced relocations, and other state practices and actions that directly and systematically targeted the Kurds in the region. And they called for firm and immediate action by the League. On one of the notes scribbled on one of the pages on the petition, it reads, "I agree. I don't think any issues regarding the minorities treaty arise since this is not a case of non-Muslim minority." Now, this is a note scribbled by one of the League bureaucrats, and it is a misreading of the Lausanne Treaty, right? Just like the Turkish state did at the time, approached the articles of the Lausanne Treaty, and continuing today. Reducing the Lausanne treaties, what we call minority articles, only as it would apply to three religious minority communities in Turkey. In conclusion, then, I had other examples, but I'm just going to sort of skip them over. At first glance, the ideological underpinnings of post-war internationalism and the liberal ideals, such as inclusion and protection of minorities, look like they may be at odds with those of the nationalist founders of the Turkish Republic. And to a large extent, they were, of course. But when we look at how these ideals were put into practice, when we look at how the League itself, through its petition system, actually processed these petitions, we get a slightly different picture where the League decisions, actions or inactions aided in the reproduction of the Turkish nationalist vision towards minorities. And this in turn meant that particularly non-Muslim minorities were locked inside what a scholar of this period, Lerna Ekmekçioğlu, calls the minorities' assimilability paradox, where the state simultaneously excluded but also forced to assimilate the non-Muslim minorities inside its territories. Thank you.
Yeşim Bayar'a çok teşekkürler. Evet, şimdi Yeşim Bayar'a çok.
We would like to thank our panelist, Yeşim Bayar, who took us back to the years of the League of Nations. Of course, we can always have more debates about the Treaty of Lausanne. One of the generic questions of debate is the scope of minorities that the Lausanne Treaty covers. But then there is another discussion, which is how to enforce Lausanne Treaty as of today. Of course, there is an answer in international law. If there is a very big time lapse between the signing of the treaty and the day of enforcement, then the current legal provisions will be applicable. This is what the international law says. So the current prevailing provisions of law will be applicable as of today. So yes, in the past, there was a minority regime of the League of Nations, but that was not actually defined as part of human rights. But right now, we have international instruments and pieces of legislation on human rights. So it is quite important to approach the issue of minority rights from the perspective of human rights. And then there is another issue, something we have been discussing with Baskın Oran at large since the 90s. So Article 45 of the Lausanne Treaty. You might remember, starting with Article 37, there are provisions on minorities, and there are also some enforcement related provisions and how minorities will be benefiting or exercising their rights. So Article 45 of Lausanne Treaty has a provision that stipulates this very provision will also be applicable to the situation of minorities in Greece. So the political elite considered that as a provision of reciprocity between Turkey and Greece, and this was even incorporated in our domestic law, be it the special education institutions or working life or our domestic regulations on foundations. So Turkey has interpreted that as a provision of reciprocity so that minorities, Muslim minorities in Greece would also be treated. And of course, they had in mind Greece while making that interpretation. And we can also read the minutes of the Turkish Parliament sessions back then. Even at the expense of having misinterpretation, they could still find some resonance with Greece because there's a country called Greece. You can have reciprocity, but how are you going to do that? Because in case of Armenian national minority, are you going to establish this with Armenia? Armenia is not even a party to the Lausanne Peace Treaty. It's the third intervener. And then for Jews, are you going to establish this reciprocity with Israel? This is not the case. So Turkey made use of this Article 45 to establish a principle of reciprocity. I have extensively written about that, and Professor Baskın Oran extensively studied that. I'm sure he will talk about this as part of his speech in this conference.